avoiding asset protection scams, tricks, traps, and ongoing monitoring. There are several frauds that consumers need to be mindful of. These could put you in hot water with the IRS and result in fines, penalties, and/or jail time. Planning for asset protection must be carried out by licensed, skilled experts who are knowledgeable about the law and adhere to all legal compliance regulations. A qualified expert with knowledge should provide you with appropriate legal guidance while you are learning how to safeguard your possessions. Steer clear of planners who guarantee to minimize or completely remove tax obligations. Each person is responsible for paying their taxes. Failure to submit taxable income to the IRS constitutes fraud. You can be sure that your asset protection strategy could put you in danger if it ever calls for underreporting to the authorities or for not reporting at all. The corporation's soul is being marketed by some as a way to avoid paying taxes and protect assets, but a corporation's real purpose is to support religious organizations. They don't require many of the formalities that commercial entities frequently require to operate. For the layperson, there are minimal, if any, tax benefits. In addition, the corporation has some litigation protection. However, there is little to no legal defense if the corporation's executives are sued. Also referred to as a constitutional trust or common law trust, Wesley Snipes was duped by it. What more has to be said? We are all aware of his fate. The most prevalent asset protection scam is the pure trust. The IRS has launched a nationwide cooperation initiative to combat these phony trust schemes in recent years. Read IRS Public Announcement Notice 9724, which cautions taxpayers to steer clear of fraudulent trust schemes that promote fictitious tax benefits. For additional information about IRS policy regarding fraudulent trusts. A trust is a type of ownership that can legally divide ownership benefits from accountability and control over assets. Trusts are utilized for purposes including estate planning and to make it easier for assets to be transferred to charities. Additionally, assets for kids and those incapable of managing their finances, including elderly individuals with mental impairments, are placed under trust. All trusts are subject to the Internal Revenue Code, sections 641 to 683, which are the tax laws established by Congress. In addition to the taxes due, civil penalties may include a very severe fraud penalty of up to 75% of the underpayment of taxes related to the fraud. Strict fines of up to $250,000 and/or up to 5 years in prison are possible outcomes of criminal convictions. Taxpayers, irrespective of the person preparing their return, bear the responsibility of paying their taxes as stipulated by Congress. Fraudulent trusts are set up to conceal the true beneficiary of an individual's income from whom taxes are lawfully owed, or to mask the actual nature of financial transactions. Taxpayers need to accept accountability for their deeds. If a taxpayer decides to take part in a fraudulent trust arrangement, they forfeit any asset protection and will not be protected from future civil and criminal penalties. Don't let the term trust fool you. It is not a valid trust just because the word trust is connected to financial transactions. Potential asset protection consultants pay $10,000 to attend a weekend course and get the title of Certified Asset Protection Consultant. This fraud is frequently set up like a pyramid scheme. Since it is not a legitimate legal professional qualification, this certification is not worth the paper it is printed on. It's important to keep in mind that an asset protection plan is not a static entity. Asset planning changes as you do. The events in your life, such as a business expansion or closure, a new marriage, or an emerging health concern, should be addressed by the asset protection plan you have in place. You have learned how to protect assets. You have taken action. Now you must regularly monitor and update your ongoing needs as time passes. This allows you to make necessary changes promptly to ensure that your asset protection plan provides you, your assets, and your loved ones with adequate protection. Your asset protection plan should reflect the current state of your business or businesses, as the case might be. It should keep up with the changes in your professional life. Whether your business grows or shrinks, when you acquire new business assets or shed old ones, as you establish your business in other states or even into international territory, your asset protection plan must be in step with these developments. Each time you establish a new business, set it up as a separate limited liability company LLC on its own. Let's say your first business was a dry cleaning shop. Your second business is a restaurant. You should keep businesses in similar fields under separate LLCs as well. For example, let's say you decide to open a store selling restaurant equipment. You already have a restaurant. Avoid the temptation to bunch them under one LLC. Cubbyhole your liability. Do this by operating your different businesses as separate LLCs. This insulates each business from a lawsuit that may be lodged against one of your business units. Keep in mind that an LLC protects your assets as well, so operating each business as a separate LLC reinforces this protection. When a predatory creditor finds out that your other businesses are each held under separate LLCs, he or she will be less likely to be able to come after the assets held in your other businesses. To do so would mean waging a separate court battle for each unique LLC. This is a legal challenge that none but the most determined creditor will likely wish to undertake. Place each additional piece of real estate property you acquire under an individual land trust. Then place each land trust under a limited liability company LLC. The reason behind this two-step process relates to the ability of a land trust to protect your privacy. In addition, you can take advantage of the asset protection features of an LLC. Once the trust agreement is executed and the trustee deed is recorded, you cease to be the owner of the property. Although the trust agreement will stipulate that you are the beneficiary of the land trust, this is a private document. Keep in mind that a trust deed is not, in and of itself, a legal corporate entity. While it does a good job of shielding your identity, it will not give you the legal protection as does an LLC or a corporation. If someone is injured on the property, you, as the trust beneficiary, can still be sued. Placing the land trust under an LLC prevents this from happening. This is because an LLC that has been properly set up effectively keeps your assets separate and distinct from the assets held by the LLC. The LLC will be the beneficiary of the trust instead of you. The more blocks you put in place between your assets and a possible plaintiff or creditor, the less likely he or she will be motivated to go after you or your assets. For tax purposes, you and your spouse will be the beneficiary of the land trust that owns your residence. For investment, rental, commercial properties aside from your residence, having an LLC as a beneficiary of the land trusts is considered prudent for both asset protection purposes and tax purposes. And in addition, a trust deed can add additional verbiage that includes estate planning features. If you clearly state in the land trust agreement who will receive the beneficial interest upon your passing, it can help your heirs avoid probate. Additionally, your spouse is only entitled to the certificate of beneficial interest in the trust and not to the trust asset itself. This ensures the continuity of the land trust in the event of future marital strife. A land trust can also prevent the partition of the land or property in case future beneficiaries disagree on its continued use or purpose. Change is the one constant element in life. This is true for your professional as well as your personal life. Some changes are eagerly anticipated, such as the birth or adoption of a child, while others may not be so welcome, such as a death or the dissolution of a marriage. You need to make sure that your asset protection plan will do just that: protect your assets in light of the events that are unfolding in the personal arena of your life. If you established a revocable or living trust, changing the terms of the trust deed is not a problem. You can do this at almost any time. However, this type of trust is not an effective asset protection instrument. It is precisely because you continue to exercise the right to amend the trust. Thus, you can be ordered by a court to change the trust beneficiary to a third party who won a lawsuit against you. On the other hand, an irrevocable trust is a potent asset protection vehicle. The assets used to fund this type of trust are placed beyond the reach of future creditors and plaintiffs. If you want to be able to somehow alter the terms of this type of trust later on without diluting its asset protection features, you must craft the trust deed with great care. When you set up the trust, you can include instructions in the trust agreement that permit the terms to be modified under very specific circumstances. This will make it possible for the trustee to alter the trust, but only within the limitations of your instructions. Let's say a beneficiary sadly dies or engages in criminal, addictive, or other wanton behavior. Or say he or she marries an unsuitable individual. In these events, trust benefits can be reappropriated, withheld, or even terminated, according to your instructions contained in the trust deed. As your liquid assets accumulate, you need to make sure you protect them more assiduously. Liquid assets such as cash, bonds, money market funds, and shares of stock are especially attractive to predatory claimants. This is obviously because these types of assets are of immediate use to them. If a creditor wins a lawsuit and is awarded a lien on a piece of real estate as part of a debtor's payment, it may take some time before he or she can convert the property into cash. For this reason, if your company is liquid, you should act quickly to secure your assets from devious claims. Consider setting up a domestic or offshore trust to hold and protect your liquid assets. Many offshore jurisdictions have strong and strictly enforced laws that are extremely favorable to trust settlers. As with any asset protection plan, having it already in place before any legal action is taken against you is best. It is a great deal better than setting it up when you're already facing a lawsuit. But even if you find yourself in the latter situation, establishing an offshore trust can still work in your favor. Many foreign jurisdictions require judgment creditors to mount a new trial on their soil. For none but the most single-minded creditor or plaintiff, knowing that your assets are kept in an offshore asset protection vehicle is enough to discourage them from going after them. Keep in mind that domestic trusts are under U.S. laws, so they may not offer the same nearly ironclad protection as offshore trusts or LLCs. Many a judge has allowed penetration of domestic trusts. Not so in the preferred offshore trust jurisdictions such as the Cook Islands, Nevis and Belize. It's no one's favourite topic, but as you get on in years you must consider protecting your assets from nursing home or extended care costs. This is simply another aspect that you should monitor to ensure that your asset protection plan is indeed comprehensive. If you bought long-term care insurance, you may already be in better shape than 92% of Americans who don't have this type of insurance. One reason is simply because it's too expensive. Many Americans prefer to bury their heads in the sand and think they will never need nursing home care. Sadly, current statistics do not support this unrealistic point of view. Up to 70% of Americans over the age of 65 will end up needing some type of long-term care at some point in their lives. If you want to leave your assets to your family instead of spending them down to qualify for long-term care from Medicaid. You should act many years before you need a nursing home or long-term care. To mitigate the cost of long-term insurance, you can buy a plan with a more limited coverage. Then you can pay for what the plan does not cover out of your savings or from some other financial resource. Better yet, you can set up an irrevocable Medicaid trust. The assets you place in this trust will not be counted in determining your eligibility for long-term care from Medicaid and will instead be passed down to your heirs and beneficiaries. Neither the person applying for long-term care nor his or her spouse can be a trustee of this trust, nor have access to or control over the trust assets in any way. These are just a few examples of instances that demonstrate the necessity of ongoing monitoring of your changing needs. You are strongly urged to take timely action to protect yourself, your hard-earned assets, and your family and/or other beneficiaries. Get in the habit of reviewing your asset protection plan at least every quarter and certainly every time an important professional or personal event occurs. In this manner, you will be assured that no matter what happens in your professional and personal life, your assets will more likely be used solely for the purpose you intended. By turning on an asset protection plan, you can greatly increase your safety from present and future creditors, as well as avoid legal risks. While many believe that creating a living trust protects their assets, many are unaware that while a living trust specifies what happens to your assets after death, it typically offers little to no protection for your fortune while you are still alive. We will talk about several misconceptions and traps to watch out for in this section. As one day merges into another, it's crucial to remember that we must accept our eventual deteriorating health and impending death. Aging increases the risk of developing major illnesses and health issues. Furthermore, as the likelihood grows, so does the necessity for long-term care, which could result in a significant increase in costs. For example, having to stay in the hospital for any length of time could wipe out all of one's money. The Medicaid trust is one way to get out of this potentially disastrous financial situation. Before needing care, the assets must be transferred into the trust at least 5 years in advance. The day you transfer the assets into the trust is the beginning of the 5-year look-back period. The assets become vulnerable if they are placed in the trust for a shorter duration of time. Thus, plan. Steer clear of the trap of neglecting your Medicaid planning. Ensure that you have a trust and that the trust deed contains Medicaid triggers. This particular phrasing is utilized to add Medicaid to your trust so that you can make long-term care plans. The Medicaid triggers, if they are present in your trust, will enable your appointed trustee to assume control of Medicaid planning if you become incapacitated. If you believe you've done everything possible to preserve your possessions for your children and grandkids far into the future, you may have already created a will or trust. Although this is a very good first step, a will or trust only covers the distribution of your possessions upon your death. What happens if one of your kids receives a large judgment against themselves and loses a lawsuit? You wouldn't want your children's adversaries to inherit your money after you pass away. A portion of the assets you intended for your child may end up going to their former spouse if your child inherits your assets, marries, and then files for divorce. You should include provisions in your trust that deal with these issues as well as others to prevent these kinds of problems one after your death. Will your assets be safeguarded for your heirs? Does the trust decide who gets your money after accounting for all possible outcomes? Does it regulate the amount of money your child can get from the trust both now and in the future? Is it feasible, for example, for the trust to disperse particular assets and/or make payments over time? This is wise to prevent a sizable portion of assets from falling into your child's possession all at once. Many parents of children with special needs also have large assets. When a parent of a kid with special needs dies, the youngster may face difficulties coping with the grief of the loss, as well as the heavy burden of inheriting problems. If you are a parent of a child with special needs, you should keep in mind not to give them the inheritance straight away. A child with exceptional needs who receives a direct inheritance may lose essential government services. Putting your child in a special needs trust is one method to keep them safe from this legal hazard. A designated trustee can be chosen to manage your child's inheritance by properly creating this trust with the assistance of an asset protection specialist. You will be able to safeguard the assets and keep your child's government benefits intact if you properly set up a trustee. When done right, this combination can provide your special needs child with enough money and care long after you pass away. A land trust may possess a personal residence. A well-drafted land trust can prevent public records from revealing your identity. Owning your property in a land trust makes it more difficult for a prospective litigant or contingency fee attorney to determine whether you have substantial resources. Property owned in a properly set-up land trust does not appear on your record. Anyone with a computer at home and your name can view the properties you own under your name by going online. It's easy for someone to find out who wants to harm you or your family. A land trust protects the owner's privacy. It is not a liability shield or an asset protection mechanism. Both are offered by an LLC. For this reason, an LLC may possess a land trust that is used as revenue property. Technically speaking, an LLC may benefit from the land trust. The LLC provides you with at least two benefits. First, if a lawsuit is filed regarding a matter involving the property, it may serve as a liability shield. Instead of coming after you directly, an LLC may fall victim to a slip and fall, fire, or other injury that sparks a lawsuit. Therefore, you reduce the possibility of a lawsuit related to the property by making sure your income property is owned by a limited liability corporation. The only assets that an aggrieved party may try to get under a limited liability corporation are those that belong to that organization. This feature helps to safeguard your overall net worth by preventing your other assets from ending up in the hands of your adversary in court. If you choose to create an irreversible living trust to protect your assets, try not to impose too many restrictions on your relationship with the assets that are held inside the trust. If at all possible, refrain from retaining the authority to revoke, rescind, or change the trust. If you do, it will not pass the asset protection trust test. Moreover, abstain from granting yourself the right to retrieve any assets you provide to that trust. Your judgment creditor can put himself in your position and take any action you can take to uphold the trust. Your judgment creditor may change the beneficiary to themselves if they can do so. The most important thing to keep in mind about irrevocable trusts is that some control limitations do apply. Many times, people choose to use LLCs and limited partnerships as additional means of asset protection. When correctly constructed, both of these legal tools can offer organizations and individuals some decent asset protection. As previously stated, some protections shield the business and its assets from being taken away if a member of an LC or a limited partner of an LP is sued. Additionally, limited partnerships and LLCs are revocable without incurring penalties or facing court intervention. You can keep control and safeguard your valuables in this way. You can better equip yourself with a stronger asset protection system for yourself and the people you designate to receive your legacy in the future by understanding how to protect assets and the traps to avoid. You should feel much more at ease knowing that you are avoiding asset protection hazards and that your assets will be safe and secure for many generations to come. Understanding asset protection dangers gives you the ability to steer clear of them, providing you and your loved ones with the security and certainty that your life savings will remain safe. Stay tuned for more information.